Good evening, and welcome to the evening version of Assembly Committee on Ways and Means. Committee Secretary, would you please call the roll?
Assemblywoman Anderson. Present. Assemblywoman Backus. Present. Assemblywoman Brown May. Assemblywoman Dickman. Here. Assemblywoman Gorlow. Here. Assemblyman Hafen. Here. Assemblywoman Howdegi. Here. Assemblywoman Kasama. Here. Assemblyman Miller. Here. Assemblyman O'Neill. Here. Assemblywoman Peters. Assemblyman Watts. Here. Assemblyman Yeager. Here. Chair Monroe Moreno.
And I am here, and Assemblywoman Peters just walked in. And will you mark Assemblywoman Brown May as absent excused? Thank you for joining us tonight. I'm sorry about the quick turnaround for those of you here in the audience. We will hear 3 bills tonight, AB 15, AB 16, and AB 268. We will start with AB 15 and welcome those that are in the audience. I don't see anyone that's down in Las Vegas. We'll have public comment, and our public comment will be at the end of today's hearing. If you have any electronic devices with you, please silence them. And please forgive my members for eating dinner. I ordered it earlier. However, the restaurant did not make our order. So I believe if you feed them, they will come, and they won't be really mad at me a lot for all these night and weekend meetings. I'm hoping, so please forgive them for eating while they're doing their work, and they will be using their laptops while they're for the meeting. Doesn't mean that they're not paying attention. They are. They're just following along on their laptops. So with that, we will open the hearing on AB 15, which prescribes the manner of increasing the base salaries for district judges. Welcome to the evening version of Ways and Means.
Chair Monroe Moreno, rest of the committee members, my name is Jerry Weiss. I'm the Chief Judge of the 8th Judicial District. It's Jerrywiese. We have Judge Dracula here with me. I'll let her introduce herself.
Thank you, Chief Judge. I am Judge Kathleen Draculich, Drakulich. I am a judge in the 2nd Judicial District Court for Washoe County.
So I want to introduce and walk you through AB 15 briefly, if I could. Section 1, Sub 1 clarifies the current salary of the district court judges is as $160,000. The $160,000 was put in place by SB 248 from the 2007 legislative session, and this has been the base salary since 2009. Section 1, Sub 2 reforms the method by which the district court judges receive cost of living increases, or COLAs, and mirrors how other elected officials receive their COLAs. In 2005, the Nevada Legislature passed AB 462, which tied the COLA increases of the governor, the constitutional officers, and legislators to the cumulative percentage increase of classified state employees. The language of Sub 2 seeks to apply the same process to the district court judges. Now, I don't think it has anything to do with what we're doing with the bill, but I don't want to keep it a secret. NRS 3.3030 also contains a longevity provision which allows an additional salary of 2% for each year of service, not to exceed 22% after 4 years of service, and the Supreme Court and the Court of Appeals also receive this benefit. Since the Nevada Constitution does not permit increases or decreases to judicial compensation during their terms, no district court judge would be eligible for the COLA increase unless they're elected or re-elected in 2026. Finally, as is reflected in the fiscal note submitted by the Administrative Office of the Courts, this bill has no immediate financial or fiscal impact on the judicial branch, as the first cost of living increase, or COLAs, contemplated therein would not take effect until fiscal year 2027. At that point, the aggregate cost of living adjustments given to classified employees of the state of Nevada would be given to the 90 district court judges. If there are any questions relating to the fiscal note submitted by the AOC, Mr. McCormick from the AOC is here to assist with that. Before I turn it over here, I just want to say thank you for scheduling the hearing for us. I'm pleased that we're allowed to come talk to you. Thank you.
Madam Chairman, members of the committee, thank you so much for the privilege of being able to talk to you tonight. Some of you I've met, the others I have not, but it's a privilege nonetheless to speak with all of you this evening. A little bit about the history of the judicial salaries for district court judges. Just to give you an idea, the Nevada State Court, or excuse me, the National State Court Association puts together every year a list that ranks judicial salaries for district court general jurisdiction judges. In 2017, the district court judges in Washoe County, or excuse me, the district court judges in the state of Nevada, with the statutory salary fixed at $160,000, adjusted for cost of living, actually ranked 15th, one being the highest. We came in at 15. That was fair and decent for district court judges. We've slipped. In the last 5 years, the increases in other states and the comparable flat salary of district court judges in the state of Nevada have now put us at 45th. So we've slipped 30 spots because we have not had increases in the state of Nevada for the district court judges. The benefits of the COLA adjustment to us are many. I want to highlight a couple of them for you. First, it would put us on parity with other elected officials and state employees who get cost of living increases, which the district court judges have not had since 2009. As you all may know, I know we've talked to some of you about this, the district court judges, or judges in the state of Nevada, have come before the legislature historically seeking raises, seeking a change to the judicial compensation. This is a different bill. If you've heard about the history of requests related to district court judges, this is not that bill. This is a COLA bill. This is a group of judges in the state of Nevada seeking parity, as I indicated, with other state and elected officials. The good news about this is, if this bill were to pass in its current form, the history that you're accustomed to with district court judges coming to you for salary raises would not be the future, because we would be getting the COLA increases every year. We would be treated like other state employees, and as opposed to coming to you and asking for lump sum increases, that would be over. It would be something that we could all plan for in the future. I want to give you a couple of examples, lastly, with regard to comparing district court judges' salaries with other salaries. District court judges are of two brands. We are either family court judges or we are general jurisdiction judges. Chief Weiss and I are both general jurisdiction judges. Let me start by saying we have an easy job compared to our colleagues in the family court. This is a difficult court. Their caseload is extraordinary. 60% of the litigants are self-represented, which presents an indescribable amount of challenges for those judges to make sure that those people are treated fairly, that they get a decent hearing, and that the decision takes into consideration every one of the issues that concerns them. On the general jurisdiction side of the street, where Judge Weiss and I are, 50% of our caseload is criminal, generally speaking. In the case of the 8th Judicial District, some of them are just criminal. We handle all cases where you can get up to a year in jail, right through a death penalty case. We see everything from sexual assaults to paper crimes to drug crimes to murder cases. The other half of our cases are civil cases, anything where you can recover damages in excess of $15,000, medical malpractice, etc. The statutory salary is $160,000. For a judge like me, I make a contribution to my PERS every year in the amount of $15,000, so my salary is adjusted to $145,000. The Justice Court judges in Las Vegas have 401k matching funds. They have a contribution to PERS and a number of other benefits. The Justice Court judges in Northern Nevada also have a number of benefits, as do municipal court judges, including car allowances, phone allowances, etc. In the Justice Court of the state of Clark County, the salaries are on average about $187,500, and in Washoe County they exceed $180,000. Most of that is misdemeanors for the municipal court judges, and the justice court judges never have to address trials. They never have to address cases that are civil that are over $15,000. And yet, on an adjusted basis, they're paid almost $40,000 more than the district court judges. With that as a backdrop, Chief Weiss and I will take any questions that you have.
Thank you so much for the presentation. We
Thank
do
you.
have a few questions. We'll start with Speaker Yeager.
Thank you so much, Madam Chair, and thank you, judges, for being here in Ways and Means After Dark. We appreciate it. So just had a question. You just talked a little bit about the difference in salaries between justice court judges, municipal court judges, district court judges. I just wondered if you had any personal experience. I mean, has that been a barrier to having folks decide to run for election? And I think about one of the recent appointments where I think we only had 2 or 3 applicants who put in for a judicial appointment. And so I know it would be anecdotal, but I just was hoping you could share any information you have about whether the difference in salaries has caused folks, qualified folks, to not want to run for district court in either the 2nd or the 8th.
You know, I love this question, but I'm going to let Judge Weiss answer it because it happened in the 8th.
So in the 8th, we've had 5 vacancies in the last little bit. We had 2 civil criminal judges recently appointed. 2 family court judges are in the process of being appointed currently, and we have one that's still on the books because the 4 people that applied did not go through the Judicial Selection Commission, meaning that they weren't the quality that they were looking for. The problem with that, I think if you look at the Justice Court and Muni Court judges, when there's an appointment or an election, you have 10, 12, 15 people that are applying for those positions. And we struggle to get 4 or 5 for each district court position. In these last 5 vacancies, we had one that we had to reopen just because we didn't have enough people that applied. So they had to reopen the position again. So, I mean, I hope that answers your question. It's one of those things that I don't have an individual name that I can tell you that person didn't apply for district court, but they did apply for justice court because of the amount of money. But I think if we look at the number of people that are applying for each of the positions, I think that tells the story.
Thank you, Madam Chair. And then I guess, you know, a number of us up here are attorneys, and I think we kind of know the difference between justice court, municipal court, district court. But I just wondered if you could speak very generally to what kind of work and what kind of things the judges in district court are doing that would be different from what happens in justice court. And if you could just kind of speak to that in broad terms, I think it'd be helpful for the record.
I'll start with this one and see if Chief Weiss wants to add. I'll give you an example. 2 of us in the 2nd Judicial District Court are business court judges. And that's a designation that comes with a statutory implication because the Nevada revised statutes require certain cases of such a complexity to go to business court judges. And everything is computerized now, but if I could give you a visual to take with you, if you were to bring in a business court judge, a business court case on a hand cart, like they used to come into our offices, it would be about 5 boxes. These are cases that involve securities. They're cases that securities as in stocks and bonds. They involve receiverships of major corporations. We also deal with medical malpractice cases on the civil side, construction defect cases. Construction defect cases can go on for years, the volume of those cases. We, on the criminal side, as I indicated, deal with anything from homicides to sexual assaults, a number of very serious criminal cases. We also have judges now that are dedicated entirely to, not entirely, but a huge piece of their caseload is specialty courts. Specialty courts are a remarkable thing. They're a way that we route people who would end up with a criminal history because they have a drug addiction that results from something that, you know, either happened to them or resulted from something occurring when they were children, et cetera. We find out about these backgrounds. These people are diverted into specialty courts. And they're remarkable courts because some of them, for example, the DUI specialty court is 3 to 5 years. Imagine that. I presided over that court for a period of time. That's a 3-year commitment to a group of people at a minimum. And it's remarkable. And then we do things like this. We monitor legislative sessions. We participate with the public. We, as I indicated, very complex caseloads. We back one another up, too. I have to say this. I know some of the judges in the 8th Judicial District that I'm colleagues and friends with, but I can say this with certainty and with confidence. My 15 colleagues in the 2nd Judicial District are 15 of the hardest working people I've ever known, and I used to be in a statewide law firm where it was not unusual for me to work 60 to 80 hours a week on a very regular basis. These are incredibly dedicated people, but the caseloads are growing. It's nothing for any of us to have 400 open cases at any given time. The nature of the crimes are growing, the drug problem throughout the state is growing, and we are battling it every day as judges. It feels much more personal to me now than it did when I was a law clerk 35 years ago because of things like specialty court. So compared to, and I would never downplay what it is my colleagues are doing in the limited jurisdiction courts. They're all needed. We are all very important, and we all perform very crucial tasks, but the district court, I would argue, requires something a little special. Chief?
Can I add a little bit? And I wasn't sure, Jerry Weiss again for the record. Assemblyman Yeager, I'm not sure if you were asking the types of cases that we handle or more generally, so I'm going to answer a little bit more generally. One of the things that we did a presentation recently for the Judiciary Committee and explained what we did as courts, and we talked about some numbers. I know that in the past there has been I think what I would consider a fallacy, but what some people think that judges don't work. And so we've done everything we can to try to document or be able to look at numbers and find a way that we could document that our judges are working or not. In the 8th, we went back and looked. In 2022, we did over 180,000 hearings. We have a new program that's been implemented in the last few years called OIC, or Order in the Court, where we electronically sign our orders. And I can tell you, I'm very proud. In 2022, we had over 231,000 orders signed. Every order follows some type of a hearing or a motion or a petition. So 231,000 orders is big. We looked at the numbers also to determine what portion of those numbers came on weekends and Fridays, and there was over 100,000 orders and warrants and things like that were signed over the weekends and after hours. So Judge Jackie, let's talk to you a little bit about the specific case types. I can tell you, she talked about specialty courts, and we did some statistics on the success of our specialty courts and whether or not we're preventing recidivism. And the stats show that about 90% of the people that graduate from our specialty courts are not committing new crimes within the next 3 years. So I think what we're doing is being successful, and I hope that answers your question.
Assemblywoman Hardigan? You have another one?
I have another one, please. Please. It's not often that I get to ask judges questions on the record, so this is kind of a pleasure for me. Usually it's on the other way, so.
I'm so sorry. Go ahead.
Thank you, Madam Chair. This is the last one, but usually I have to answer the question, so this is nice for me as a practicing attorney to ask the judges. So you mentioned a little bit, Judge Weiss, that there are things that happen after hours. This is not an 8 to 5 sort of job, so I just wondered if you could, what are those kind of things that you as district court judges are tasked to do after normal working hours or on the weekends?
Jerry Weiss, again for the record. So some of the things I talked about are the orders and warrants. We have, at least in the 8th Judicial District Court, we have warrant phones because the Justice Court takes care of simple warrants, but anything that involves a wiretap or some type of electronic warrant requires a district court judge to sign. So we have warrant phones that are transferred between judges as the year goes on, and you have a secondary week and a primary week. I can tell you on the primary weeks, generally we get about 120 warrants, and those are generally after hours. Sometimes at midnight, 1, 2, 3 o'clock in the morning. We wake up and do a telephonic warrant for somebody because they're at a crime scene and they need to get into a car or a house to investigate a murder or something else that's happened. We do that. As far as the orders and things like that, those are things that we just do when we get a chance. My law clerk emailed me on the way up here and said, you need to sign a bunch of orders before tomorrow. So when I'm done here and I get home at midnight or 1 o'clock in the morning, I'll be signing orders just because they need to be done before tomorrow. Other than that, I mean, the majority of things, I think that you'll find that not all, but many of the district court judges do things outside the office, like legal education in schools. Project REAL is one of the things that they do down in Vegas a lot. I swear in student council officers at different schools, things like that, because we're trying to educate kids so that they're not afraid of the judicial system. They know that we're there to benefit the community. Anything else that you wanted to say?
I'll just add, the business court, as I indicated, is very, very demanding. I left a business court order in process to come here, and I'm going home to finish it, but I also have a criminal calendar tomorrow that has a very stacked calendar. You don't walk into a criminal court and just sit there and read names. You go home tonight, you look at the binder. If there's sentencings, we're talking about somebody's life here. You want to go all the way back to the beginning. You want to read that pre-sentence investigation report. You want to look at how they've performed if they're out of custody. You want to give them the benefit of the doubt related to how well they're doing when you consider probation or prison. And I, like Judge Weiss, will be working very late tonight to finish the business court order on a deceptive trade practices case and then move into my criminal calendar in time for tomorrow morning.
This Judge Jerry Weiss again, for the record. Let me just follow up with that, because one of the things that maybe people don't understand about a judge's schedule is when we have a calendar or law in motion calendar in the mornings, that doesn't mean that we walk into that calendar, as Judge Draculich said about sentencings. Whether it's a civil case or a criminal case or a family civil domestic case, it takes hours of preparation and legal research to be able to be prepared for those motion hearings and to understand the legal basis for the motions and the oppositions. Then we go in and listen to the arguments. Oftentimes we're writing the orders after hours, because if we're busy in court all day, then we have to get them done sometime. But yeah, there's a lot of hours it takes to be a judge. Thank you.
You're welcome. Assemblywoman Hardigan.
Thank you, Madam Chair. And you answered my question a little in your presentation, but just hearing what my colleague said about having a vacancy and only having 2 people apply for it, that's concerning to me, right? When I think of our legal system, I think of wanting the highest qualified attorneys to seek the bench, right? And I'm afraid, just like with every other agency that comes before us, if the salaries aren't competitive, then we will continuously lose them to the private sector where they can go and make more money, and we won't have the highest quality people filling these seats. And so you had mentioned in your presentation a little bit about putting us on parity with other states and being 15 and then regressing to 49, and if this is passed, then we would be at parity with other states. But with what states, where would that put us on the sliding scale? If we were 15 and now we're 49, if we pass this bill, where would we fall in that line now? Would we be in parity with the top states who pay their judges,
Yeah, it's a great question. If it would be 6 years from now, this is Kathleen Draculich, by the way, remember, it would be 4 year, it would be, 2027. So it would be the next time the Second Judicial District Court judges are elected, and I'm thinking, let me see. I'm going to look at, I would say, looking at the 2022 rankings, doing the math in my head, knowing what the COLA is worth between 2009 and now, and adding that to the statutory salary, that would put us right at about 178, or tied with Missouri at about, is that Montana? At about 15th, in that range, somewhere between 15 and 20.
follow-up, Madam Chair? Could you, do you have that information about what, if we're 15th, what do the top states pay there?
Oh, what do
for
the top
judges?
states pay? All right, let me find, number one is District of Columbia, 200 is, are you looking at, that's it, 232 is Illinois. I'm looking at 2000, what year do you have there? Right. Okay, same with this, District of Columbia. Then number two is 212,000. Number three is 211,000. Number four is 207.
Okay.
And then they move down incrementally from there. We'd be right in the 170,
Okay.
170s.
Thank you. And just, if I could, one follow-up, just to make. Go ahead. Thank you. And then, so the way the additional salary of 2% works is if judges elected year two, it increases 2% until, say they don't seek reelection, and the new elected coming in would start over, and then they wouldn't seek that 2% until, they wouldn't receive the 2% until their second year.
Right.
Okay, perfect.
Now we don't get the 2% now until 2027. If I don't run again and someone runs for my seat, that person is going to come in at the base salary in 2027 statutorily. So it would be the 160 plus the COLA catch-up in 2027.
Thank you. Thank
Okay.
you for being here.
This is Judge Weiss, can I just follow up on that? I'm assuming you're talking about the longevity 2%. The longevity doesn't kick in until the fourth year that a judge has been a judge.
They
Just
require
so we're clear on that.
they require some dedication.
Yeah, so you have to run and win, and then as a new judge serves, they start getting longevity after 4 years. Okay?
Good clarification. Thank you.
Assemblyman Miller?
Thank you, Chair. It's been a struggle trying to make sure that I don't have food in my teeth before I speak.
It all smells really good, just so you know.
But food is my love language, so I'm okay with it. I just am curious, when we look at vacancies, what type of impact that is actually having. So when you say that there's like 200,000 orders that you've been able to do over the year, when there's a vacancy, how does that like impact those numbers? How many more could we be processing? How many more people could we be serving? Or, I mean, maybe what's the average load on a particular judge, and how does that, impact?
It's Judge Weiss. So you're not going to like the answer, but I don't think that we would have any more orders signed due to our vacancies, because when we have a vacancy, they're generally filled by senior judges. We have a senior judge program through the Supreme Court. So if a judge retires, or we had one recently pass away, when that happens, we have a senior judge that generally fills in for them, and they're signing that judge's orders anyway. So I don't know that the vacancies that you're talking about changes the number of orders. The number of orders is going to be the same. We're going to have that. We're just going to have a different judge hearing those cases while there's a vacancy. Does that make sense?
Yes, thank you. So I just wanted to make sure that or just kind of understand if there is a vacancy, like how hearings and orders and all that stuff, are folks being missed in what's being, what we need to serve, or is it extending out how much longer it is before we can see them, but we're still being able to serve folks with those vacancies?
That's the benefit of having the senior judge program, because I think we're running out of money in our senior judge program because we're using them quite a bit for these vacancies. But at the same time, we try to provide the access to service to every citizen in the community that comes in. So, yeah, just because if your case is assigned to a judge who retires and we have to wait 2 or 3 months or 6 months for that appointment, it doesn't mean that their case is just languishing. Somebody's going to be covering that case during that time period. It's just not a full-time judge. It's a part-time or not. It's a per diem judge, one of these senior judges that we get through the Supreme Court.
Gotcha. Thank you. Thank you, Chair.
Thank you. Assemblywoman Bacchus.
Thank you so much, Madam Chair. I thought I would take an opportunity to do the reverse and ask questions of the judiciary, even though I really didn't have one. But I have a kind of a statement, and then I can end with a question. But one thing is, I think you did really underestimate the amount of law that you have to cover as when you have a civil docket. My colleagues and I know that we are working with over 700 chapters of the Nevada Revised Statute, and any of that could come before your department along with other state laws as well as common law, all sorts of crazy stuff they did research, as well as maybe international laws. And one thing is when you're, and I'm glad someone did touch on what you have to do to prepare for hearings, because when I heard, oh, we have a hearing, we have an order, I know lawyers like myself love to write over 30-page briefs, try to seek leave to sneak that in. And then it's not just that, it's the multitude of exhibits, and you hear about maybe 10 of those complex motions and a calendar in your morning. And the other thing I know we do in the 8th, and I don't know if you do it in the 2nd Judicial District Court, is when a court may not be in trial or have a hearing. I know Judge Weiss has oversat our settlement conference program, which allows matters to come in when judges have availability to fill their time with trying to do alternative dispute resolution to resolve a case more quickly. So that's kind of my statement, and my question will be to the 2nd Judicial District Court. Judge Drakovich, I know Judge Friedman had sat in your place a few years ago and had indicated that when the civil criminal judges had free time, they were also covering family court matters. Are you guys still doing that?
We are not doing that because the legislature was so gracious and filled the need that we needed in the 2nd Judicial District Court for extra family court judges. And so I want to thank you for that. That was a heavy lift. That was a huge undertaking for those of us who were crossing the street to do that. But thanks to the legislature, those spots were filled. And now we have 2 new family court judges in the 2nd Judicial District. If I might, Assemblywoman Bacchus, add to something that you just said, which is the settlement conferences. I neglected, and I think Judge Weiss and I both should have mentioned to you, this is a very important thing that you've pointed out here. We have very complex cases, and we are sometimes 5 and 6 set on a Monday morning. So you're looking at your calendar today, and you're in court, and someone says, I want to set this for June, the first Monday in June. You look at that and you're 6 deep. The crims go first. Crim cases take precedence. So you have 3 crims and you have 3 civil. We need to manage these. We say to the parties in a pretrial hearing, what do you think? You think your clients would be amenable to settling this case? Because I have 8 amazing colleagues, and I am willing to reach out to them and find out if somebody can find a day, a half a day, and try and settle your case. I do it for my colleagues, and they do it for me, and we pass the baton readily. And it's a day where you come in the morning, none of us, you come into another judge's case. You have to go back the history of that case. You have to read every motion that was filed in that case. You have to read every order that your colleague has signed in that case just so that you can prepare. Recently, I did a settlement conference for one of my colleagues. We had 3 jury rooms on 1 floor and 1 courtroom because we had 1 plaintiff and 3 defendants in a civil case. And I was there until 8 o'clock at night, but we got it settled. And the court reporters are amazing because they're waiting. We put these on the record because the Supreme Court says if you put them on the record, they're binding, no backing out. But that's another day that you take maybe 6, 7, 8, and in this case 10 or 12 hours to settle someone else's case so we can get that trial docket and start to minimize it so when that week comes up or you're 6 deep, we have judges for those cases.
You sure you don't want to ask any more questions like the? Go ahead.
These are complex questions. I feel like I'm giving really easy questions. With respect to the rankings of the judicial salaries, are those like an average? They take an average of like District of Columbia? Because I know for us in Nevada, when we're looking at doing the math of what the longevity pay may be on top of what the salary is, we have a lot of, I know in the South, we have a lot of younger judges, so it would lean more to the 160. I wasn't sure if the rankings were I'm assuming they're average across the board.
Thank you for the question, Assemblywoman. This is Kathleen Draculich. I want to make sure I'm answering this question. The salary numbers that I gave Assemblywoman Howdiggy, are related to general jurisdiction courts adjusted for cost of living. So they're low. If they're not the actual salary, they're adjusted for cost of living. So if you want the actual salaries, they're quite a bit higher. Yeah, but all of the numbers I gave you were from the cost of living adjusted column, so there's parity there.
Members, any other questions? Assemblyman Hafen, are you sure? Well, seeing no other questions from the members, I thank you so much for the presentation. I truly appreciate you bringing a different bill. I think when we met in my office, I've told you I've been in this body for now 4 sessions, and every session that I've been here, we've had a bill. But this one is different because you're not asking for a pay increase for yourselves, much like we can't. But for anyone that comes after you. So I appreciate the difference in this legislation than in previous.
Thank you. Thank you. Chair, thank you for the privilege.
Thank you. Seeing no other questions, we will close the hearing on AB 15. And we will invite the presenters for AB. Oh, sit down, sorry. God. Yeah, it is ways after dark. Yep. All right, okay, we will not close the hearing. We will go, all those that would like to. Would testify in support of Assembly Bill 15. Please take a seat at the table, and please forgive me for passing you up for a second.
Thank you, and good evening. My name is Tom Gregory. I'm a district court judge in Minden, Nevada. I'm here today, however, in my capacity as president of the Nevada District Judges Association, and here to speak in favor of both AB 15 and 16. I'll let Mr. Hillerby introduce himself.
Thank you, Madam Chair. Michael Hillerby, representing the Nevada District Judges Association.
I would just like to say the association is very much in favor of this bill. As a judge, it's very uncomfortable to have to come and have discussions about our salaries and COLAs. Just like one of you mentioning a moment ago, talking about giving yourselves raises. So I do so humbly here today. I think there is wisdom in this COLA bill, in that we won't have to keep coming back to you each year. This is a different bill than you've seen in the past. We heard what you said in the past, and we think this bill addresses it. And so very much would ask you for your support. I do want to say something about your rural district court judges, because you heard from Vegas and you heard from Reno. Your rural judges, we don't have business courts and family courts and all of these different types of courts. You have one judge who handles all of those cases. So I might get that business case that Judge Draculich talked about. I might get a murder case. I also do family law cases, child dependency cases, juvenile cases, and on a daily basis make decisions impacting the welfare of children. So we want and need Nevada to have the best and the brightest judges to handle those cases. This bill furthers that interest, and I thank you for any support you give, and really we're so happy to have a hearing here tonight. So thank you much.
Thank you, Madam Chair. Again, Michael Hillerby. You have been gracious enough with your time. I was prepared to answer any questions or provide some history on the current system for constitutional officers and legislators. I will not do that. It's late enough on an evening hearing. Again, we'll be happy to answer any further questions you might have. And again, thank you for your time and your consideration.
Thank you. Do we have anyone else here in the audience that would like to provide testimony in support of Assembly Bill 15? Go ahead and turn your mic on. Sorry.
Lydia Stiglich, and I testify in support of my colleagues on the district court bench. I echo much of Judge Gregory's comments, but to follow up on what the speaker had alluded to, District court cases are serious cases. They're for serious people. They're going to make decisions about families, whether your parental rights are terminated, the most intimate relations that you have in your home, about your custodies, your divorce, your water, your taxes, issues of the Constitution come forward, how somebody is sentenced, whether it's for the rest of their life or they're given an opportunity to go back into the community, what services we can get for them. Your district court judges are there to be commended, and I'm very proud of them. The Supreme Court stands in support of our district court judges. We're proud of the work they do. They work very, very hard, and we want the best. We have wonderful people currently. We want to keep them. We want the best and brightest in state service, and appreciate that might not be the place to get rich, but it has to make sense for people. We want to encourage service, attract, and retain. So I want to thank you for your time. Thank you.
Thank you. See no one else here in the audience to testify in support, and I see no one in Las Vegas. BPS, do we have anyone on our phone lines who'd like to provide testimony in support of Assembly Bill 15?
Chair, the public line is open and working, but there are no callers wishing to provide testimony at this time.
Thank you so much. Is there anyone here that would like to testify in opposition to Assembly Bill AB 15? Seeing none, and I see no one in Las Vegas. BPS, do we have anyone that would like to provide testimony in opposition of AB 15? Seeing none, is there anyone here would like to provide testimony in the neutral of AB 15? Seeing none, and I'm assuming no one jumped on the phone line. BPS, is that correct?
You are correct, Chair. No one is wishing to provide public testimony.
Thank you so much. So now we will officially close the hearing on Assembly Bill 15. And we will move on to the next item on our agenda, which is Assembly Bill 16. Assembly Bill 16 prescribes the manner for increase for the base salary of judges for the Nevada Supreme Court and judges of the Nevada Court of Appeals. Welcome.
Thank you, Chair and members of the committee. For the record, I'm John McCormick, John, last name Mccormick. I'm the Assistant Court Administrator at the Nevada Supreme Court, and with me is
Lydia Stiglich, Lidia Stiglich. I'm a justice on the Nevada Supreme Court, and I'm here to testify on AB 16.
And a lot of this may sort of sound like a broken record here, so I have to make a confession. The real reason we did two bills is not because it got way too complicated because of the Supreme Court staggered terms and the Court of Appeals and everything. It's so I could have a cheat sheet on what the questions would be from the committee, so I already knew how to answer them. I will not repeat too much of what Judge Weiss and Judge Draculich said, but the last Supreme Court compensation increase was in that same bill in 2007 and took effect in 2009. But with the Supreme Court staggered terms, that means that it took effect 2009, 2011, and 2013 because we have 2, 2, and 3 as far as the seats. And then as far as the Court of Appeals, their compensation was initially set at 165 in the enabling legislation this body passed in 2013 after that Senate resolution passed the second time. And then that went into effect in 2015 when the court when that court began. Also, a note on, it's a subtle difference on longevity that is afforded to the Court of Appeals, but the Supreme Court receives additional compensation based upon their service on the Pardons Board. So there's no actual longevity statute in Chapter 2, if anybody's super interested in that. And at any rate, AB 16, again, is modeled on the bill Judge Weiss mentioned, AB 462 of 2005, and it increases, provides COLA increases for the Supreme Court and the Court of Appeals based upon the preceding 12 years of service. So how that will work is the next 3 justices who are, the first raise that would occur will be in 2025 because we have 3 justices up for election in 2024 and then 2 more in 2026 and then 2 more in 2028. So the Supreme Court raises are spread out in that manner. And the Supreme Court, or the Court of Appeals were all just reelected, or a new member joined that court in this past election. So those increases will not occur until 2029. So that kind of covers it. Basically, in the bill itself, you have Section 1 is broken into 3 subsections, and that handles the 3 cycles of Supreme Court justices and their election and the cost of living increase. And then Section 2 provides that for the Court of Appeals judges. And so here's where my cheat sheet comes in. We did recently have a vacancy on the Nevada Supreme Court, and we received 6 applicants for that vacancy on the state's highest court. So if that is any indication there. Have I missed anything? All right. So I would stand for questions rather than keep just mumbling here.
We appreciate that. We will start with Assemblyman Speaker Yeager, who promises that there will be one question, but that could change.
Thank you, Madam Chair. I'm going to try to get all in one question rather than do a follow-up. It's good to see you. Thank you for being here. I know the answer to this, but I think it's good for the record. At least I know the answer to the first part of the question. How many Supreme Court justices do we have in Nevada? How many Court of Appeals justices do we have? And the second part, so I want to ask a follow-up, do you have numbers for what the pending caseload is in front of the Supreme Court and in front of the Court of Appeals?
Thank you, Mr. Speaker. John McCormick for the record.
While John gets those numbers, I'll handle the first part. There's 7 Supreme Court justices. Lydia Stiglich for the record. 3 Court of Appeal judges. Roughly 2,000.
Well, currently, the current pending caseload for the Nevada Supreme...
State your name for the record
Oh,
again.
sorry about that.
Thank you.
John McCormick for the record. The current pending caseload for the Nevada Supreme Court is 1,036, and the pending caseload for the Court of Appeals is 86. That's down significantly from its highest point before the Court of Appeals was created. That pending caseload is a little bit of a misnomer because some of those cases are sort of in the pipeline. They're currently being briefed or being studied and bench memos prepared by staff or however that goes, excuse me. But at this point, just a little bit of a horn blow here, the Supreme Court's last fiscal year, had 101% disposition rate, and the Court of Appeals had 107% disposition rate, meaning they're disposing more cases than are actually being filed currently.
Thank you. Assemblywoman Backus?
Thank you, Chair. I just had it, and I may have misunderstood you, John, but Mr. McCormick, I wanted to, I thought you said this, but I am shocked by this. So the Court of Appeals judges has the longevity pay, but our Supreme Court justices, I was trying to look at the statute really fast and didn't see it. Do they have longevity pay?
For the record, John McCormick, the Supreme Court justices do receive the longevity pay, but theirs is tied to their service on the pardons board. So they get the, they do get the longevity, but it's not in Chapter 2. It's actually in the pardons board chapter, which I always forget where it is and then have to go look it up. But they do get it. It's just done in a different statutory manner.
Madam Chair, may I ask a follow-up?
Go ahead.
Just with respect to that, is the longevity pay consistent that our Supreme Court justices are on par with the Court of Appeals as well as the District Court judges? And then do all 7 serve on the pardons board?
John McCormick for the record. Yes, it is consistent. It's up to 22%, and they begin getting it after 4 years of service on a state court bench. So District Court, and then District Court, Court of Appeals, or Supreme Court. So the service is cumulative for that. So it is the same amount longevity-wise. And constitutionally, all 7 Supreme Court justices do sit on the pardons board.
Assemblywoman Hardage.
Thank you, Madam Chair, and thank you for being here. And I just have a very similar question as to my questions, your cheat sheet, as to my questions on the previous presentation. But where do we stand in comparison to other states? And where would this bill, if passed, put us? Thank you.
Lydia Stiglich, for the record, I think previously we were at, where were we, 25? 25.
Just is your mic
I'm
on?
sorry. Yeah, previously we were hovered around 25. The most recent pay study from the National Center on State Courts puts us at 44. So we are in with Guam, Northern Mariana Islands, Puerto Rico, Kansas, West Virginia. That is where the Supreme Court currently stands in terms of compensation.
And Madam Chair, follow up just quick. And if this bill passes, where would we be in terms of parity with other states?
John McCormick for the record, and being the way this is constructed with the COLAs and all that, and there's some unknowns there, it would bring us to about 25th, right in there, depending, for the Court of Last Resort. Being the Supreme Court, the Court of Appeals currently ranks 35th.
Members, any other questions? Okay, seeing none, then we will move to those who would like to provide testimony in support of Assembly Bill AB 16.
Good evening. Tom Gregory with the Nevada District Judges Association, representing all of Nevada's 90 district court judges, and we are in support of this bill. Thank you.
Thank you so much.
Good evening, Jerry Weiss again, Jerrywiese. Similar to how Justice Stiglich was supportive of our bill, we're supportive of theirs for the same reason. We want the best and brightest, the best quality justices on our Supreme Court. They're the ones that hear our appeals from the lower courts, so we want them to be the best we can get. Also, I'm going to make sure that we'll send a copy of this to all of you so that you have this. This is the stats that we've been referencing as far as how we rate compared to other states. We'll get that to your committee.
Thank you so much. We appreciate that. Is there anyone else here in the audience who would like to provide testimony in support of Assembly Bill 16?
Thank you, Madam Chair. Kathleen Draculich from the 2nd Judicial District. Like Chief Weiss, I echo support for AB 16. Thank you.
Thank you. Seeing no one in Las Vegas, BPS, by chance, did we have anyone call in to provide support and call in for support, opposition, neutral? Just get it all done on the phone now.
Chair, the public line is open and working, but there are no callers wishing to provide testimony at this time. Chair, the public line is open and working. There are no callers wishing to provide testimony at this time.
Thank you. So we will move to opposition. Is there anyone here in Carson City that would like to provide testimony in opposition? Seeing none, is there anyone here that would like to provide testimony in the neutral? Seeing none. All right, and I think we've said all you need to say about the bills. We can close the bill hearing. Awesome. Then we will close the hearing on Assembly Bill 16. And thank you so much for joining us here tonight, especially on such a short notice for both of us. And with that, we will move to the last bill on our agenda for today, and that's Assembly Bill 268. Welcome to Ways After Dark.
I feel like I've seen this show before. Thank you, Madam Chair. Thank you, Madam Chair. For the record, my name is Ben Kiekeffer. I serve as Chief of Staff to Governor Joe Lombardo. Pleasure to be here today to present Assembly Bill 268, which is the implementation of one of the governor's budgetary priorities that he announced during his State of the State address. Assembly Bill 268 would provide a $500 quarterly retention incentive for all executive branch state employees, to recognize them for their service to the state, and to help each state employee cover some of the rising costs of living that have been impacted due to significant inflation increases in our state over the past years. This would be an acceleration of a bonus, an incentive that the governor has proposed for the next biennium, paid for with one-time cash on hand. We have asked, and this body very graciously introduced this bill to accelerate this retention incentive into the current fiscal year, so that it would provide funding for those incentives to be paid out for the final 2 quarters of the current fiscal year. So the way the bill is written is that if you are an employee of the executive branch of state government on March 31st of 2023, and then again on June 16th of 2023, that you would be eligible for the $500 retention incentive. We focused this legislation on the executive branch because of the significant vacancy rates that we've seen throughout state government, that you've heard testified to throughout all of the budget hearings that you've probably had in the past however many weeks, that represent 25% of the legislative session. And that was our primary focus. As you are all aware, we do not have the ability to change budget requests as they come to us from the legislative branch, from the judicial branch, other branches that are outside of the State Budget Act. And we tried to align this legislation with those, particularly for the current fiscal year, but also as they were budgeted for in our one-shot request for the next biennium as well. So just for a little bit of perspective, the employees that would be covered under this bill as it's currently drafted total 16,597 state employees. The average hourly rate for those employees is $29.62 an hour. And so if you were to average out that retention incentive across all state employees, it would represent, and annualized at $2,000 a year, it would represent a 3.2% retention incentive for all state employees. But when you focus that down onto those employees who are at the lowest bands of state employment salaries, if you combine those making less than $50,000 a year in annual salary, it represents about a third of state employees, and all of them would receive a retention incentive that would equate to a minimum of 4% of their annual salary annualized. So if there are any implementation questions, I'd be happy to try to answer them, but I have brought in my brain trust with me, who is Ms. Amy Stevenson, the Director of the Governor's Finance Office, and we'd be happy to address any questions you might have. Thank you, Madam Chair.
Thank you. I know that we do have a few questions, and I appreciate in your presentation why my question was going to be why was only the executive branch employees included in the legislation, and your explanation that you didn't have the ability to address those others, but luckily we can.
Yeah, can I clarify, Madam Chair? Yeah, no. Look, the governor could have. We could certainly propose, I think, sort of whatever we want. We were focused on the executive branch of state government because this was this proposal sort of developed over time as we were transitioning into the new governor's administration, and we were rolling through each executive branch agency and its budget request. And the biggest issue we heard about talking to every agency was their vacancies and the ability to attract and retain employees. And it just spurred out of that. We weren't having those same conversations with the court and the legislative branch because of that statutory structure. But I'll leave it at that. Thank you.
Thank you. And you had stated the number of employees. Could you give me that number again? I was writing and.
Right. The number that I have calculated, Amy's giving me an eye. Maybe it's changed. Hold on.
Amy Stevenson for the record. The number that he gave you, which was 16,597, are current on the payroll rolls now and does not include NG.
And the average pay of those 16,597?
That would be $29.62 an hour.
Perfect. Thank you. I believe I have a question from Assemblywoman Anderson.
Thank you, Chair, and thank you for bringing forward the language. I have two questions, but I'll ask them both at the same time. Since these are considered a bonus, is it taxed at a higher rate? And also, is this something that can be utilized for PERS compensation or PERS calculations?
Thank you, Ben Kiekover for the record. This would be outside of the PERS structures, so PERS deductions would not be made out of this, and it would be. I will defer to Amy to talk about the tax rate.
Amy Stevenson for the record. The current tax rate on this is 1.45%. I don't know if that's higher or less, but that's the tax rate on it.
Thank you so much for that clarification, because I know sometimes when there's a bonus, it does in fact get compensated at a higher rate for the taxes. And follow up. I'm sorry, Chair. Thank you. And so just to make sure, the plan is to have the first payment go out in March, and then the second is to happen in June. Is that understanding the language from the bill?
Ben Kiekover for the record. So the dates cited in the bill are the sort of deadlines for employment. So if you are employed as of March 31st, then you would be eligible for the third quarter retention incentive, and that would be paid out not on March 31st. It would be paid out at a subsequent pay period as it gets processed. We're in the process of determining exactly when that's going to be. It could be up to a few weeks later, potentially 4. But if you're employed on March 31st, you would be eligible for that retention incentive regardless of what you do on April 1st. So if you sever service on April 1st, you'd still be eligible for it since you were employed on March 31st. The same is true for that subsequent date. And those dates were chosen based on the fact that they are they're payroll dates. So there's something that happens in the system that makes it an effective time to make that determination.
Thank you for the clarification around the dates, and that it could be up to 4 weeks after those dates. Thank you very much, and thank you, Chair.
Thank you. And the bill as written would apply to both part-time and full-time employees, correct?
Amy Stevenson for the record. Yes, that is correct. It's FTE, whether it be half-time or full-time FTE.
Thank you so much. Speaker Yeager?
Thank you, Madam Chair, and thanks for being here tonight. Former Senator Kiekover, as you know, we've been talking a lot in this building over the past several years about doing right by our state employees, and I'm certainly excited about the proposals coming forward, and I view this as one of many proposals to try to do right by our state employees and make sure we're retaining and recruiting talent. So appreciate this coming forward. My question kind of dovetails off of Assemblywoman Anderson's question that, one of the deadlines here is March 31st. That'd be the deadline for employment, but how soon do we have to get this bill to the governor's desk to make sure that the folks who are employed on March 31st get this bonus for the first quarter?
Amy Stevenson for the record. We would have to before March 31st if we wanted to. So anytime between now and March 31st to get that first payment up.
Thank you, Madam Chair.
Assemblywoman Hardy, go ahead.
Thank you. And so just to confirm, the first payment would go out 4 weeks from March 31st or 4 weeks from when the bill is signed?
Thank you, Ben Kiekover for the record. Assemblywoman Hardy, it would be up to 4 weeks, and if we would accelerate it as quickly as possible, but it would be up to 4 weeks after that March 31st date. So hopefully the payment will be made before the end of April to the employees. And it's cash out of the current fiscal year. So for that second payment for the final quarter of the year, the payment itself would be made probably in July, but the appropriation is out of the current fiscal year.
Members, any other questions? Assemblywoman Peters.
Thank you, Madam Chair. I'm just, it's late. Can you talk a little bit about NG employees and how they fit into this? Because it's my understanding that they're like executive branch, but then they're also NG. So how does that fit into this bill?
Thank you. Ben Kiekover for the record. NSHE employees are included in this bill, so they're not included in that number count that Amy and I gave you, but they are included in the budgetary figure and would be receiving the retention incentives as well.
Thank you for clarifying.
And I have even further clarification. Are those NG self-supported or state-supported?
Ben Kiekover for the record, Madam Chair. Those are, I think, all employees of NSHE.
Well, then the numbers that I'm looking at, that would not include all of the NSHE employees, and the amount that's in the bill would not, as written, would not cover all NSHE employees.
Madam Chair, for clarification purposes, it is budgeted at a level that is designed to support both classified employees and faculty of NSHE. If they have, as you know, their budgets are not always as readily transparent as the executive branches, right? So whether there are faculty members that are being supported in self-supporting budgets, I can't really speak to, but it's designed to cover faculty and classified employees.
Thank you for that clarification, because I've been in discussion with our fiscal staff and leadership, and I don't believe the bill as written would have the amount appropriated in this bill to cover all of that. And we've sat here and we've heard presentations from everyone across the board, from the executive branch positions, folks from NSHE, NDOT, the judicial branch, and the legislative branch. And I would have issue as a fiscal leader in this body to only give bonuses to the executive branch. So I will be instructing my staff to bring back for the work session on this bill what it would look like to include the executive branch, the NSHE classified, NDOT, judicial branch staff, and the legislative branch staff. Not including the session staff, I'm sorry, because it's a retention and to keep people, and what those numbers would look like truly at the work session. Because I think if we are going to give bonuses to our employees that have been with us through thick and thin, it needs to be across the board.
Thank you. Ben Kiekover for the record, Madam Chair. So fully understand how you decide to move forward in processing the legislation is certainly your jurisdiction. I will clarify, NDOT employees are included, and so even employees that are funded currently out of the highway fund would be eligible for this retention incentive as well. So we've tried to capture as many people as we can, sort of under the purview of what we characterize as the executive branch, but happy to see what you bring forward.
Thank you. Members, any other questions?
So, Madam Chair, can I clarify really quickly as well?
You sure can.
So, the number that we quoted you was 16,597 employees, but we penciled it from a fiscal perspective at 28,000 FTE. So, yeah. Implementing a 20% vacancy rate for 22,000 400 employees at $1,000 each times the tax rate, getting you to the $22,750,000. So it's, I don't know the count that you're working off for NSHE employees, but we've penciled it at 28,000 FTE.
28,000 FTEs, but that doesn't include the part-time positions, just the full-time positions, or is that
Full-time
full-time
equivalent,
and-
full-time equivalents.
Full-time
So,
equivalents.
Yeah, so all people, even if they're half-time. So, yeah, it's everyone, whether they're part-time or fulltime.
Could you give the formula
Could you give
again
that-
one more time?
Sure. Based on 28,000 FTE, so people, with a 20% vacancy rate, making it 22,400 active employees, calculated, okay, not active employees, 22,400 people at $1,000 times 1.45% in taxes that the state pays, totaling $22,750,000. Rounded up to $23 million in the bill.
So with those calculations, those would just be the employees that would be included in the bill as presented today.
Correct.
I will be adding more dollars to that.
And people.
Do you have a question?
Yeah.
Assemblywoman Hardigan?
Thank you. Okay, I think that just confused me a little bit. So the 28,000 FTE, who do you calculate in that number? I think I'm,
Amy Stevenson for the record. So those 28,000 FTEs is everybody that's in our central payroll for executive branch. So it's an actual FTE, whether it's vacant right now or not. So it's a position.
yeah. So that's, may I, Chair? Go ahead. So that's the executive branch, and within the executive branch, it's the state agency employees, it's NDOT. Could you list who you're covering under that 28,000, the different?
Do I know all that?
So, who are not part of the executive branch. So it's NDOT.
Amy Stevenson for the record. So NDOT is part of it, so that's why that's a little confusing for me. But NDOT, NSHE, and I believe that is it. And then the rest of the departments under the governor.
Thank you. Ben
Okay,
Keycover
and
for the
I-
record. So other constitutional officers, the entire executive branch of state government.
I'm going to ask our fiscal staff to put some clarification on the record.
Thank you, Madam Chair. In researching this particular bill, fiscal staff did reach out to the Nevada System of Higher Education to determine how many positions they have. It was our understanding that the bonuses would be provided to positions instead of full-time equivalent. And as such, they do have a significant number of part-time staff. Those amounts that we received based off of the state-supported accounts was $12,102.66. For the self-supported accounts, there was 6,708 positions. For the grant-funded accounts, there were 2,229. And for the gift-supported accounts, there was 499, for a total of 21,539 positions.
Assemblywoman Hardigan?
Okay, that's where my confusion came in. So you're telling me that of the 28,000, 21,539 are NSHE employees, and then the remaining about 7,000 are just executive branch? So, because you said we were including all of NSHE, so 21,539 of that 28,000 that you mentioned is NSHE.
Ben Keycover for the record. So our calculation includes about 8,000 employees who are not currently in, a little less than 8,000, who are not in our state central payroll system that would be attributable to NSHE. So there's some sort of difference between the numbers that Ms. Kaufman quoted and the numbers that we used when creating the calculation. So we'll have to sort through it.
Members, any other questions? So as you sort through it, I will ask that you work with our fiscal staff because obviously there's a difference in the numbers. But I have put on the record what I'm going to ask them to bring back for our work session of who I believe that we will be able to afford to cover, and making sure that we encompass as many of our state employees who have stayed with us through thick and thin, making sure no one's left out if at all possible.
Madam Chair, for the record, Ben Kiekeffer. I just also want to point out that this is a proposal for not just the next 2 quarters, but for the 8 quarters that follow. So it may be worth looking at it for a fiscal impact for an entire biennium as well as we get into that exercise.
Oh, definitely. That is what I'm looking at. Thank you. All right. Seeing no other questions, I'll thank you for the presentation, and I'll ask if there's anyone here in the audience that would like to provide testimony in support of Assembly Bill 268. Please come up and fill in the chairs.
Good evening, Chair Monroe Moreno and members of the committee. For the record, I'm Cisco Aguilar, Secretary of State. I'm speaking in favor of AB 268. Our offices only work because of the people in them. We can't bring our state offices to the modern age or implement strategic plans to better serve Nevadans without fair and competitive wages for state employees. I know you're working hard to find a solution. Thank you. The ability for the state of Nevada to adequately serve the people is only possible because of our incredibly hardworking staff. Like many other agencies, the Secretary of State's office is critically understaffed. Even though our office is one of the highest generators to the state general fund, we still can't pay our employees the wages they deserve. AB 268 would be an amazing gesture to those employees who have stuck with us through thick and thin. Thank you.
Thank you. Go ahead.
Thank you, Chairwoman Monroe Moreno, and members of the committee. For the record, my name is Susie Martinez, and I am the Executive Secretary Treasurer for the Nevada State AFL-CIO. And on behalf of over 150,000 members and 120 unions, the Nevada State AFL-CIO supports Assembly Bill 268. Our state government employees work hard in and out to keep Nevada moving, and for that, we thank them. This legislation will ensure that the executive branch workers that guarantee our government continue to run can continue doing their hard work without financial stress. Retention incentives, such as the one proposed in this bill, make sure that we continue to have people with vital institutional knowledge within our government. I urge the committee to pass Assembly Bill 268. Thank you.
Thank you. Go ahead.
Good evening, Madam Chair, members of the committee. For the record, Randy Saltero, representing the American Federation of State, County, and Municipal Employees, AFSCME. We are grateful for the state to offer these incentives. We know that in the next budget that there is some language that could be helpful in that regard as well. I think it's been said before, and I know everybody knows that our state workers are dealing with a lot and has been there through the pandemic. The folks at unemployment that were overworked and had to deal with thousands and thousands of more claims that they were normally used to. Just to point out one, I appreciate what this committee is doing to make sure and examine all those numbers and make sure that everybody is going to have this opportunity to get this bonus and retention. With that, AFSCME supports AB 268. Thank you so much.
Thank you. Go ahead.
Doug Unger, DOUG, UNGER, UNLV Chapter President and Government Affairs Representative, Nevada Faculty Alliance. Colleges and universities are also suffering critical staffing shortages, especially at the junior levels. In my own department, we've suffered 3 losses of employees who've gone on to other things. mainly because of salaries and really despair about salaries. Among our classified staff, we have a constant turnover. We're constantly training in our departments new classified staff to do the administrative work of the English department, which serves 13,000 students per year. The English department at UNLV is larger than many small colleges all on its own because it teaches all the basic writing courses and sophomore literature courses. I just want to say university-wide, we immensely appreciate the effort of this legislature to include NSHE employees in this bonus, and that it's sorely needed and it will make a difference. So thank you for your support for AB 268.
Thank you. Go ahead.
Kent Irvin, ERVIN, Nevada Faculty Alliance. Ditto to what has been said. I am here in support on the representation that NSHE is included. We are part of the executive branch. We've been told that we're state employees over and over. But there are a lot of different categories of employees at NSHE, and we'd be happy to be a resource on those categories. If we're talking about part-time, that includes, of course, semester-by-semester contracts and lots of other folks. So we'll help with that. I do want to say thank you for fast-tracking this. It won't happen overnight because payroll has to do payroll, and that gives me an opportunity to give a shout out to NSHE Payroll Services, who did magic to get the furlough reimbursements out before the end of the calendar year, before other state employees. But we are also state employees. Thank you.
Thank you. I don't see anyone else here in the room that would like to provide testimony and support, nor do I see anyone on the camera in Las Vegas. BPS, by chance, have we had anyone join us on our phone lines?
Chair, the public line is open and working, but there are no callers wishing to provide testimony at this time.
Thank you. Is there anyone here to provide testimony in opposition of Assembly Bill 268? Seeing none. Is there anyone that would like to provide testimony in the neutral on Assembly Bill 268? Seeing none, I will ask the presenters if you'd like to come back up with any closing remarks.
Thank you, Madam Chair. Madam Chair, Ben Kiekefer for the record. I just want to say thank you for the quick introduction and hearing on Assembly Bill 268. We know that taking care of state employees is a shared priority of both the governor and the legislature, and we look forward to partnering with you this session to make sure that we move significantly in the right direction on that front. Thank you.
Thank you. And with that, we will close the hearing on Assembly Bill 268. And the last item on our agenda tonight will be public comment. Is there anyone here in the room that would like to make public comment? Seeing none. And I don't see anyone in Las Vegas. And I don't believe there's anyone on the phone lines to make public comment. So I'm going to say thank you for joining us here tonight. Forgive the short notice, but it is legislative session, so I think we'll see each other a few more times in the evenings and on the weekends. So with that, this meeting is adjourned.